Sorry.
Thank you very much, Mr. Vice President, distinguished delegates, Indigenous peoples representatives, ladies and gentlemen. I have the honor to present today my third annual report to the Human Rights Council. I would like to start by expressing my gratitude to the numerous states, Indigenous peoples and others, in particular to the Office of the High Commissioner for Human Rights, for the support they have provided as I have carried out my mandate over the past year as I begin my third as the Special Rapporteur. Each year since my appointment as the Special Rapporteur on the rights of Indigenous peoples has been historic for Indigenous peoples. In 2014, I addressed the Council a few days before the World Conference on Indigenous Issues. The conference culminated in the adoption of an outcome document which reaffirmed states' commitment to the UN Declaration on the Rights of Indigenous Peoples. 2015 was the year in which negotiations for the post-2015 development agenda and a new agreement under the UN Framework Convention on Climate Change were finalized. This year marked the negotiations to strengthen the mandate of the expert mechanism and discussions regarding participation of Indigenous peoples with a differentiated status in the General Assembly. Next year, we will celebrate the 10th anniversary of the adoption of the Declaration in the General Assembly. Closing the gap between the recognition of Indigenous peoples' rights at international and national levels and the actual implementation on the ground remains my main preoccupation, and I reiterate my commitment in my role as a Special Rapporteur to monitor closely member states and the United Nations on how they are implementing the Declaration and the outcome document. While seeking to cooperate as appropriate with relevant international mechanisms and institutions, I have engaged in a range of activities within my mandate. The various activities I have carried out can be described as falling within four interrelated areas of work. These are promoting good practices, doing thematic studies, country reports, and responding to cases of alleged human rights violations. In this presentation, I will focus on my thematic studies and my 3 country visit reports from the past year. Mr. Vice President, as you know, a core aspect of my mandate is to examine ways and means of overcoming existing obstacles to the full and effective participation of the rights of Indigenous peoples and to formulate recommendations and proposals and on appropriate measures and activities to prevent and remedy violations of the rights of Indigenous peoples. As I have mentioned in numerous statements, I have focused my efforts particularly on issues surrounding economic, social, cultural, and environmental rights of Indigenous peoples. The thematic report I am presenting today is the second of 3 reports that I dedicate to international investment agreements and their impacts on Indigenous peoples' rights. Previous special rapporteurs have addressed the impact of large-scale development projects and investment plans on Indigenous peoples. However, this project-level focus did not extend to addressing structural constraints that arise as a result of the international investment law regime, which facilitates these projects and investments. My 2015 report to the UN General Assembly sought to address the impact of the international investment regime in the context of Indigenous peoples' rights. My current report to the Human Rights Council further contextualizes and examines these impacts and presents a number of recommendations aimed at guiding member states, the UN system, and the actors involved in the international investment law regime. It seeks to promote coherence across international investment law and international human rights law to ensure that state fulfillment of duties pertaining to the rights of Indigenous peoples is not obstructed by protections afforded to investors. My research reveals an alarming and growing number of cases where foreign investment in the mining, oil and gas, hydroelectric, and agribusiness sectors is resulting in serious violations of Indigenous peoples' land, self-governance, and cultural rights. The legal vacuum arising from the lack of recognition or enforcement of Indigenous peoples' land rights is facilitating arbitrary land expropriation for such investment projects. The vast majority of these lands are then protected under the international investment agreements. Related investor-state dispute settlement claims are expected in Africa and Asia in the agribusiness and extractive sectors. In the Americas, a growing number of ISDS claims already exist in relation to such activities in or near indigenous territories. In such context, international investment agreements can and do contribute to and exacerbate the serious impacts of investment projects on indigenous peoples. This arises as a result of three interrelated issues. A, the failure to adequately address human rights in the preambles and substantive provisions of international investment agreements. B, actual or perceived threat of enforcement of investor protections under ISDS arbitration, leading to regulatory chill. And C, the exclusion of indigenous peoples from drafting, negotiation, and approval processes of indigenous investment agreements and from the settlement of disputes that arise in relation to investor protection agreements. My report also includes some observations in relation to the Trans-Pacific Partnership Agreement. 11 of the 12 TPP countries have significant populations of indigenous peoples in host territories, and resource exploitation is widespread. In regional and international workshops I organized, these peoples and experts on international investment law expressed their concerns in relation to lack of protection for indigenous peoples' rights vis-à-vis those of foreign investors in the imbalance in remedies afforded them. They also criticized the absence of consultations in the negotiation of the TPP and the lack of human rights impacts assessment. In their responses to my questionnaires, a number of states acknowledged the need to reform extant ISDS systems. They also emphasized the importance of guaranteeing the regulatory space necessary for the realization of indigenous peoples' rights, including the requirement for prior consultation and with the objective of free, prior, informed consent. I encourage other member states to respond to those questionnaires which are available in English, French, and Spanish, as this input will continue to inform my ongoing work in that area. I believe it's possible to develop a system of international investment law that reduces risks to indigenous people's rights and serves to benefit them and the state while providing investment security to foreign investors. Both short-term and longer-term reforms at the level of international investment law will be necessary to realize this. I also wish to refer to my report to the General Assembly this year, in which I explore how conservation measures affect indigenous peoples and recommend measures to increase respect for indigenous peoples' rights. While protected areas have the potential of safeguarding the biodiversity for the benefit of all humanity, these have been associated with human rights violations against indigenous peoples in many parts of the world. I had the privilege of being invited to present this report before the International Union for the Conservation of Nature World Conservation Congress, which was held in Hawaii the first week of this month. I won't go into the details of the report because you can see this in my website. I just want to stress that in the Conservation Congress, they came out with resolutions that address the issues that I have raised in relation to the violations of rights of indigenous peoples. In terms of country reports, I would like to mention my report related to the countries I visited. I would like to thank the country, Brazil, Honduras, Norway, Sweden, and Finland for inviting me to visit countries. The Norway, Finland, and Sweden visit was a working visit. In the Hemavan conference in Sweden, which was done at the request of the Sami Parliamentary Council, the governments of all the three countries and civil society organizations, including the Sami Council, an umbrella organization which represents the interests of the Sami peoples in the region. I assessed the fact that the Nordic Sami Convention hasn't still been approved, although the deadline was to have this approved in March 2016. And I also mentioned the mineral acts of Norway and Sweden, which are found to be not consistent with respecting the rights of indigenous peoples. I received comments from the government of Norway and Finland, and I thank them very much for these comments, and I would certainly wish to sustain the communications and dialogue with them to further address the issues which they want to be clarified, as well as some of the inaccuracies they pointed in my report. In the mission to Honduras, which I visited in November 2015, I would like to state that my report contains a lot of the serious situation of violence faced by indigenous peoples in Honduras, and this has garnered international attention and condemnation due to the murder of renowned indigenous Lenca leader Berta Cáceres. Because of this horrific event and its implications on indigenous rights defenders in Honduras, I prepared an appendix to the report on Honduras about the situation in Rio Blanco that specifically addressed the human rights problems generated by the Agua Zarca Dam and the obligations of the state, business enterprises, and international financial institutions in the context of these and other similar projects. Finally, the visit I had in Brazil is also another important visit, and I had noted in my report that Brazil has a number of exemplary constitutional provisions pertaining to the rights of indigenous peoples and was in the past a leader in the area of demarcation of indigenous peoples' territories. However, in the 8 years since the visit of the previous mandate holder, there has been a disturbing absence of progress in the implementation of his recommendations and of the resolution of long-standing issues of key concern to indigenous peoples. I noted a worrying regression in the protection of indigenous peoples' rights. In the current volatile political context, the threats facing indigenous peoples are exacerbated, and the long-standing protection of their human rights is at risk. Brazil owes a historical debt to its indigenous peoples who have suffered marginalization and discrimination since the formation of the state. Despite the hardships they have endured, they remain unwavering in their resolution to preserve their lands, to maintain and develop their cultures, customs, and languages, and to determine their own future. Rather than being seen as a burden on the state or an obstacle to national development, their contributions to Brazilian society should be widely recognized and fully appreciated and celebrated. I would like to thank the government of Brazil for the comments which it provided to my report, and I would like to address some of them. The recent statement made by the Minister of Justice and Citizenship, Alexandre de Moraes, where he reaffirmed the commitment of the government to the promotion and protection of the rights of indigenous peoples is indeed a welcome declaration. I also welcome his commitment to strengthening the National Foundation for Indigenous Peoples, FUNAI. I hope more adequate support will extend to the local FUNAI offices in order for them to provide much needed and adequate support to indigenous people's rights. Following my visit, I received a report that in April 2016, the government took a number of steps to protect the rights of the Munduruku, whom I met when I was there in Brazil. This included initiating the demarcation of the Sauri-Moibo territory and suspending the licensing procedure of the Ministry of Environment for the São Luís do Tapajós Dam based on the position by FUNAI that the project was incompatible with indigenous peoples' constitutional rights. I certainly welcome these positive developments, and I hope that these measures taken will be sustained and further reinforced by the new government. Lastly, and with regard to the Belo Monte, during my visit, I was told and witnessed firsthand that mitigation has not been adequately implemented in a timely manner, as backed by documents received from FUNAI and the Ministerio Público Federal. Mr. President, before I end my report, I would like to mention the promotion of good practices during my second year as the Special Rapporteur. I have continued to provide technical assistance to governments in their efforts to develop laws and policies that relate to indigenous peoples. These are included in the longer version of my statement in the OHCHR website. Mr. Vice President, as a special rapporteur, I am called upon to contribute to ensuring indigenous peoples are effectively heard and to facilitate a dialogue between indigenous peoples. I would like to thank the governments of Australia, Guatemala, and Chile for inviting me for future visits in the country, as well as a working visit to Mexico. I would certainly call on all the governments whom I have written to request for a visit to please respond and to allow me to visit the countries so that we will be able to come up with clear recommendations and a very sustained dialogue on how indigenous people's rights can be addressed and responded to. Thank you very much, Mr. Vice President.